Keep back talking. You better take that out of here. Oh, don't give me that look. Lee, get her out of my courtroom. Get her out of my courtroom. Court will pass that matter. Court does call the case of YPF 16 LLC versus Nakia Turner.
But yeah, and I sent in my SER through the mail. I didn't know I had to come and actually bring her here. I don't have a car, so anytime I go anywhere, I have to get on a bus with my children.
The judgment, I'm not dealing with August.
I know that. I'm just let you know for sure that's going to be paid. That's all. But thank you. Have a nice one.
So she can take time off work at St. Joe's so she does not lose that job. Other than that, Your Honor, we respectfully request an adjournment of the sentencing.
I think that he will.
Well, I don't doubt that.
Stop by my office, or I'll ask them to give you the paper printed out.
Good afternoon, Your Honor. David Fantier on behalf of the plaintiff.
Your name?
Kia Fleming.
All right. Where are we on this case?
Ms. Fleming has a balance of $4,298.39. She indicates that she mailed the rental assistance form to the court on Wednesday.
She mailed it on Wednesday?
Yeah, I didn't know. I couldn't really hear you, but I thought you said mail it in, so I mailed it in.
Well, it needs to
proof
be at
that
the court by
that I filled out an SIR with my tracker number and everything. I mean, an SER.
I don't have it. So.
Well, I sent it in.
Your Honor, I'll leave it up to the court what the court wants to do. I don't think her balance is $4,298.39. She's been on rapid rehousing with SOS paying their portion. She's never made a payment to my client. And I reached out, and from what she has said, so I reached out to SOS to see if they were going to be able to help her with the balance. What she indicated to
Anyways,
me.
can I talk? They're not going to be able to help. They're not going to be able to help with.
Ma'am. Let him finish, and I will then hear from
I don't
you.
like.
You want to know what? You don't try to overtalk me, because that will never happen.
That's fine.
Am I understood?
Yes.
You know what? I'm going to pass the matter. You go down, check your attitude, and then I'll call your case back up. Have a seat. Have a seat.
Man, you about to piss me off. Come on.
Keep back talking. You better take that out of here. Oh, don't give me that look. Lee, get her out of my courtroom. Get her out of my courtroom.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. From the very first seconds of this hearing, the temperature in the courtroom is already boiling over. We're looking at a landlord-tenant dispute involving YPF 16 LLC and Kiara Fleming, with over $4,298.39 on the line. But this isn't just about unpaid rent. It's about rapid rehousing assistance, missed paperwork, and a judge who clearly demands respect and order. Notice how quickly the focus shifts from financial details to courtroom behavior. When emotions take control in front of a judge, it can completely reshape the outcome. The real question is this about inability to pay or failure to follow procedure? And as we move forward, watch closely, because how someone acts in court can matter just as much as what they owe.
Court will pass that matter. Court does call the case of YPF 16 LLC versus Nakia Turner.
From the very start of the hearing, the tension between the parties is palpable. The judge states that Fleming owes $4,298.39, but Fleming insists that he mailed the assistance documents on time. The issue here is not only about money, it's also about miscommunication. Fleming claims he submitted the paperwork promptly, yet neither the opposing side nor the judge accepts this. Throughout the proceedings, Fleming interrupts and responds emotionally, which only heightens the tension. The judge gradually loses patience, at one point snapping with harsh remarks like, "Don't test, me leave the courtroom." What stands out is that the dispute shifts away from a strictly legal matter and becomes more about behavior and courtroom conduct. Instead of focusing solely on legal logic, the judge pays greater attention to how the parties present themselves and follow courtroom decorum.
Your Honor, I'll wait for it.
That just messes up my whole day. Everybody else is gonna have a hard time with me now. You know, I was in a good mood and then it's just gonna take one person. It just takes one person and just messed up my whole attitude. You know? Nakia Turner. That's
Your Honor, I filed an administrative closing on this case. I was able to verify with her bankruptcy attorney that there is a bankruptcy in both their names.
okay.
And so I gave to,
And I will sign the order for administrative close.
great.
Got it. And YPF 16 versus Christina Morgan. That matter is dismissed on plaintiff's motion without. And so we only have her?
Yes.
Do I want you to go get it? Not really, but I don't want to hold up Mr. Pantera. Tell her she can come back in now. You know, people, if she don't act right, it's gonna get bad. No, hey, I'm just telling you. I'm just giving fair warning.
Would you like your coffee, sir? So we can go get it for you right now.
No, I'm good. I don't know about the rest of you, but I'm good.
We respect you, sir.
Your Honor, if you want to pass.
I'll pass it and then. No, you know what? You keep talking, I'm gonna do something to you too. Courthouse case, so Augusta Woods versus the Joeldine Ballard.
Good afternoon. Good afternoon, Your Honor. David Santa Croce on behalf of Shelby Mink. Oh,
Okay, got it. Is she in the premises or
so I
PF 16 LLC versus Kiera Fleming? Parties have returned. Mr. Pantera, you were in the middle of your statement, sir.
Yes, her current balance is $4,123.39. Court costs of $175 for a total of $4298.39. She's been in rapid rehousing where SOS has been paying her portion and she's supposed to pay the rest. She has never made a payment. I reached out to SOS. They tried to reach out to her. And it's my understanding that the rapid rehousing ends at the end of July. So in August, she's going to be responsible for the whole thing herself. She hasn't filed a rental assistance form. I don't think there's a tribal.
This is the pivotal legal moment right here. When the plaintiff says there's no triable issue of fact, what he's arguing is that there's nothing for the court to debate, no factual dispute that would require a trial. From a legal standpoint, unpaid balance plus no documented assistance form equals grounds for judgment. But here's where it gets complicated. Fleming insists she mailed the paperwork and just regained employment. So we're watching a collision between strict legal standards and financial hardship. The judge now has to balance procedural compliance with real-world struggles. If you were in that seat, would you prioritize the paperwork or the person? And remember, once a judgment for possession is granted, the clock starts ticking fast.
Issue of fact, we would ask the court for a judgment.
Right. Ma'am, what did you wish to say?
Anyway, like I was saying, SOS was paying my rent for 3 months without me having to pay anything. Like I told Miss Terry through SOS that I ended up losing my job and I wasn't able to pay. nothing at the moment, and I'm just now getting a job, and I wasn't able to pay nothing until today. But yeah, and I sent in my SER through the mail. I didn't know I had to come and actually bring it here. I don't have a car, so anytime I go anywhere, I have to get on a bus with my children.
As the hearing continues, the judge wraps up other cases and returns to Fleming's file. The plaintiff firmly states that Fleming's total debt amounts to $4,298.39 and that he has never made a direct payment. According to their argument, state assistance SOs only covered part of the balance, while the rest has remained unpaid. Moreover, they emphasize that this support will end after July, meaning that starting in August, the entire burden will fall on Fleming. The defense, however, tries to explain his circumstances. He lost his job, recently started working again, claims he mailed the documents on time, and points out delays caused by difficulties in caring for his children. At this point, it becomes clear that the dispute is not only about money, but also about Fleming's living conditions, limited means, and personal struggles. The judge, meanwhile, seems intent on steering the case toward a more serious stage and moving closer to a final decision.
So I don't know if you're able to, if they bring the mail to y'all, but I definitely sent the SER to this courtroom with the judge with your name on it, Cedric Simpson.
Did
But SOS doesn't stop. She said that I already filled the paperwork out yesterday when she came. They pay August, but after August, I won't be getting no more help from SOS. But I reached out to Hawk. They're able to help, and I did do an SCR with my caseworker, and I have an appointment with my caseworker on Monday for help, so I can get help with my rent. And I'm able to pay altogether $900 today, but that's all I can afford.
Well, if we get to August 1st, then August rent is going to kick in, which means you're not going to be.
No, August rent is paid by her, by SOS.
I'm going to let you finish because I'm not going to be interrupted again.
I'm sorry.
So what else did you want to say?
That's all I had to say. That's what I said. It was already paid. August month is already paid. That's why she came over yesterday and I filled out the paperwork. So August month to be paid. After August, September, I won't be getting no help after August, is what I'm telling you.
If SOS pays in August what they paid in July, it would be $650 on a $1,300 apartment, which would mean she'd be responsible for the other $650.
That's not true.
But even without, let's assume that for the sake of argument that SOS is going to pay the whole thing. She still has a $4,200 balance, and I don't think there's any way that's going to be paid. And she hasn't filed the form, even though, you know, the previous person heard you just fine last week when you said, we get it here within 5 days. It wasn't here within 5 days. We'd ask for a judgment today.
I did turn it in within 5 days. You said turn it in Wednesday, which I did turn it in Wednesday. And who is he to say that I won't have all of it paid? Like, you don't know that. I didn't know I can get as much help as I did until I reached out to all these companies. And I was unemployed for a while, which I just got a job. I just started working 3 weeks ago. So this is my first check. You have to wait 2 weeks in a hole to even get your first check.
Your Honor, I'm willing to extend the judgment, normally be the 28th. If we were to extend the judgment to August 4th.
There's no tribal issue for this court in regard to this case. I'll grant a judgment for possession with the redemption amount of the $4,298.39 with the writ to issue August 4th, 2025. Thank you.
Can you tell me exactly what does that mean?
I just issued a judgment, the 4,298.39 will need to be paid on or before August 4th of 2025. I've done it that way because if I grant an adjournment in this case, quite frankly, whatever the dispute is with the August rent would be added on to this figure, which I was trying to say earlier.
Yeah.
So it's a benefit that if you can find the funds to get this paid, you only have to pay this amount. Does not include anything for August.
Okay.
Right,
Well,
so you have to the 4th to get it paid.
yeah, but last thing I gotta say is that when I talked to my SOS worker, Miss Terry, our agreement was for her to pay the full amount because she know I'm not gonna be able to pay the full amount. The money that I have now is going to be towards to the money I already owe. So August is already gonna be paid. Like the full amount is gonna be paid, so I won't have to worry about August.
Maybe you're not hearing me.
I'm not, I'm
I just
hearing what you
issued
said.
the judgment. I'm not dealing with August.
I know that. I'm just let you know for sure that's gonna be paid. That's all. But thank you. Have a nice one.
In the final stage, at the end of this tense and exhausting process, the judge carefully considers the parties' arguments before solemnly announcing the decision. The core issue remains unchanged, Fleming's old debt of $4,298.39. The judge firmly and clearly rules that this amount must be paid. By August 4th, he stresses that the ruling applies strictly to this figure, meaning that any rent after August will be treated as a completely separate matter for Fleming. This ruling is simultaneously harsh and somewhat hopeful if he can somehow secure the necessary funds. Paying only this debt would resolve his conflict with the landlord. The judge frames the decision both neatly and correctly from a legal standpoint, while also allowing a short grace period in recognition of Fleming's social circumstances. Yet ultimately, the burden is placed squarely on Fleming's shoulders. His true ability to pay, his already difficult living conditions, and his uncertain future remain painfully unclear. What emerges vividly is the sharp tension between social fairness and legal logic. The law imposes its rigid demand, but the human reality tells a completely different story.
Move stop.
Nope, doesn't work.
Don't miss the test.
Time that was originally set for sentencing. I have reviewed or received and reviewed the recommendation from probation with Ms. Johnson. She has not, we do acknowledge she has not completed the alcohol screening and assessment through Von Schwartz, and she did miss a test on July 1st. I did discuss this with her yesterday on the phone and advised her to go to community corrections as soon as possible to try to test. She informed me, and so did her father, who is here with her today, that she did go to community corrections this morning before court and was there for about 45 minutes, and they said she was unable to test this morning. We are respectfully requesting that the court not remand her at this time and that we adjourn the sentencing out in August to give her the opportunity to complete the alcohol screening and assessment. She is gainfully employed at St. Joe's. She does not want to lose that job. In the alternate, if the court is inclined to remand her in both speaking with Ms. Johnson and her father, our request would be to potentially allow that remand to happen a couple weeks in the future so she can take time off work at St. Joe's so she does not lose that job. Other than that, Your Honor, we respectfully request an adjournment of the sentencing.
At the very start of the hearing, the judge poses one of the simplest yet most critical questions. Why wasn't the alcohol screening and evaluation completed? The response is weak and unconvincing. I forgot to print it out. The defense quickly tries to soften the blow, admitting that the defendant not only skipped the test, but also failed to finish the evaluation. Still, the attorney adds that on that morning, the defendant did go to the center with his father, though he was unable to complete the test. This explanation sends the judge a message of at least an effort was made, but the core issue remains unchanged. The conditions were violated, and there is no serious or credible excuse behind it.
And Teresa Clare on behalf of probation. Your Honor, I did communicate with community corrections this morning. She did go over, and she wasn't scheduled to do a test today, so she did not test. She did do her download of her scram. I just confirmed with them that there was no violations on the scram. However, she had not reported to them after June 15th. So there was quite a bit of info that they had to download on that. So I do know that there was no violations on the scram. However, probation also wants to point out to the court that this court did direct her back on April 3rd, I believe, and warned her about any further mistesting. So she was given a warning by this court back in April about her remaining compliant with the testing.
Why?
Why, what?
Why'd you miss a test? I mean, I gave you a huge break back in April and just told you, just don't miss the test. You remember that, right?
Yeah.
And then when you pled, why didn't you do your alcohol screening and assessment?
Forgot to print it out.
What?
I said I forgot to print it out.
Oh.
Charged with originally. And you have a hearing. First, you have a bail hearing, and the court wants to give an assessment of you, or get an assessment of you. And one of the things they very often require is drug and alcohol screening. They don't want you drinking or using drugs for whatever reason, depending on your case. And she obviously got in trouble, and the judge, and I've seen Judge Simpson before, he tries to cut people breaks. But this woman did not follow it. She didn't come for alcohol screening. And now her excuse is, I didn't print it out. Folks, print it in your brain. You should know.
They do so much. I mean, I didn't send you the last time. I'll re-refer to defendant Tuvon Swartz for completion of her alcohol screening and assessment. Young lady, understand something. If you don't do it, and I don't have that alcohol screening and assessment, the only thing that I can really sentence you to is the maximum time. And I don't want
The
to.
paper?
What?
The paper?
What?
All the lists on it?
Up to this point, the situation can no longer be brushed off as a mere technical delay. The judge makes it clear that he has already shown leniency in the past, but now sees that a second chance has been wasted. An excuse like I forgot to print it out carries no weight in court, as it comes across only as irresponsibility and disregard for the rules. Both probation officers and the judge emphasize that if the conditions are not followed, there is no alternative. It will either be the maximum penalty or immediate jail. The judge's stance here is both instructional and punitive, calling the young woman to accountability, while at the same time warning her in no uncertain terms that there will be no leniency next time.
What is Von Schwartz?
That's for your alcohol screening and assessment.
Is there somebody I'm supposed to go to? What does that name stand for?
That's somebody that you need to call to set up an appointment so that they can interview you and do an assessment.
Okay.
And Your Honor, my office, I know that the clerk's office sends things out. My office also sent an email to her on June 5th with assessment in addition to the information to complete the victim's information.
Now she's just sunk herself, and she could have been. All she had to show up. And alcohol screening, by the way, just so you understand, drug screening can tell in many instances whether you've been using.
Need to pay a $75 referral fee. Do you have that?
No.
Adjourner sentenced August 28, 2024, 9 a.m. Young lady, you are leaving me with no options. And I have a feeling that if you don't follow this, that I'm going to end up sending you for the maximum time. I don't want to do that. I'm going to end up finding you in contempt and sending you. So in this, I'm going to, for the bond violation, I'm going to remand her for 3 days. Washtenaw County Jail for the bond violation. Defendant's remanded. Just go. Is that Dad?
Yes, sir.
Get her back. Dad, hang on one second. Go ahead, take her back. Come on up, too. Can you come up to the phone? What's your name, sir?
Tony Johnson.
Okay. Can you help try to get her through the,
Yes, I will definitely make sure that she does it. She lives with her mom, So I don't kind of know the things that kind of goes on. So I'm just coming to support, and I just was hoping that you didn't take her to jail because
I know.
she need this job so bad.
I know. And trust me, I did not want to. Miss Clara, can you give to Dad the Von Swartz information and the victim's impact information so that he has it, so that I get where he is, so that he knows what she has to do?
Yeah, sure.
So
I do know, I heard him in the hallway, really getting after her for not doing things. So I think that he will.
Well, I don't doubt that.
If you stop by my office, or I'll ask them to give you the paper printed out.
Through his ruling, the judge made it clear that failure to comply with court conditions is not treated as a minor technical mistake. It is considered a direct bond violation. Despite repeated warnings, the defendant showed irresponsibility and ultimately faced incarceration. The 3-day jail sentence serves both as a punishment and as a warning. It is meant to be the final alert before harsher sanctions in the future.
2 separate hearings, 2 very different situations, but the same underlying theme: accountability. In the housing case, the judge granted a judgment for possession with a redemption amount of $4,298.39 due by August 4, 2025. Legally, that means if the full amount is paid before that deadline, eviction can be avoided. It's firm, but it leaves a narrow window of opportunity. In the second matter, repeated non-compliance with alcohol screening conditions led to a 3-day jail remand for bond violation. The judge made it crystal clear: second chances aren't endless. Court orders aren't suggestions, they're obligations. What we witnessed here is the constant tension between human hardship and legal structure. The court can show patience, even empathy, but it cannot ignore violations. So now I want to hear from you. Were these rulings fair? Should the judge have shown more flexibility, or was this the right call under the law? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
The judge himself stressed that his goal was not to impose the maximum penalty, but that there was no other option left. In the end, the court maintained balance. It imposed immediate accountability while still leaving the defendant an opportunity to set things right. Supported by her father's guidance.
Is that in this building?
It's right down the hallway.
Okay.
And so I'll tell them you're coming right down.
And,
Okay.
I have the $75 for any fee or whatever that she might have needed to pay. I do have the money, so.